Friends, Legal Breeze welcomes you for a discussion relating to Election Commission of India. The Constitution has set up two election commissions. In fact, in the old textbooks, whenever you read, they used to say there is only single election commission in India which conducts elections throughout the territory of India. It is true. It conducts elections for the Legislative Assembly and the Legislative Council, if it is there in the state, and for both the houses of the Parliament. In addition to this, it also conducts elections for the President as well as for the Vice President offices. So, two houses of the Parliament, and if there are two houses of the legislature, if there are no two houses, at least the Legislative Assembly of the state, then the President and Vice President offices elections are conducted by the Election Commission of India. There is no doubt about it. But there is another election commission is also there, but it is not called as Election Commission of India, it is called as State Election Commissions. The original election commission or the Election Commission of India was originally constituted by the constitutional framers when our constitution has been originally framed. Okay? But the State Election Commission has been later on constituted by the 73rd and 74th Amendment in our Indian Constitution. So that is the difference. The State Election Commission conducts elections only to the local bodies such as municipalities and Panchayat Raj institutions. Or to put it differently, it conducts local elections for the urban and rural local self-governments. So that is why it is called State Election Commission, but it does not conduct elections at the state level legislature. That you should keep remembering. Then as I have told, Article 243 deals with the State Election Commission, whereas Article 324 to 329A deals with the Election Commission of India. Out of these 5 plus articles, Article 329A has been repealed by the 44th Amendment. That also you should remember. But prior to the repealing of this Article 329A contains 5 clauses. Clauses 4 and 5 has been struck down by the Honorable Supreme Court of India in the leading case called Indira Nehru versus Rajnarayanan. In this particular case, certain portions of Article 329A has been struck down. Thereafter, the Janata government has come to the power at the center. It has repealed the entire 329A. This is a history you should remember for your civil service examination or other examination is concerned. So, Article 329A has only academic importance or historical importance and doesn't have any practical importance today. From 324 to 329 deals with the Election Commission of India. Article 324 is very important out of these 5 provisions. It talks about the composition of the Election Commission. It talks about the powers and functions of the Election Commission. It talks about the terms and conditions and services of the offices of the Chief Election Commissioner and other election commissioners. These are the few important aspects which has been dealt under Article 324. Above all, the 3 words or one sentence, the heading of Article 324 is very important. What it says, superintendence, direction, control shall be vested in the Election Commission of India. Please remember, this is a similar language used in Article 1, 2, 3 of the US Constitution. For that matter, even you can refer Article 52 of the Indian Constitution also. Article 52 simply says all the executive powers shall be vested in the hands of the President of India. So it doesn't say all the powers relating to the election shall be vested in the Election Commission of India, but it carefully chooses the word. The superintendent's direction and control of the elections, including the preparation of electoral roll and other aspects of conducting the elections, as I have told, to the relevant bodies and offices shall be vested in a commission called Election Commission of India. So this is where the naming is also given, Election Commission of India. What is the composition of the Election Commission of India? It can be a corporate sole or corporate aggregate, depending upon the wishes of the Parliament. What is this corporate sole and corporate aggregate? It can be, this office can be inherited by one person, or it can be a multi-member body. It can be a mono-member body or multi-member body. Who shall decide it shall be a multi-member body or not? The discretion has been given to the Parliament of India. Based on the legislation made by the Parliament of India, it is the duty of the President to appoint either one election commissioner as the Chief Election Commissioner, or along with the Chief Election Commissioner, whether other election commissioners can also be appointed. If the Parliament Act says, then he has to appoint other election commissioners also. Please remember, the Constitution provides some more power to the Parliament. Not only the election commissioners, other than the Chief Election Commissioner can be appointed, it also paves way for appointment of regional election commissioners. So this is also very important. So all of them, whether all of them are having equal powers, unfortunately, no. This is a discrimination. But who can decide whether they can have the equal powers? Again, the discretion has been given to the Parliament. Parliament may regulate all these things by virtue of a law made by a Parliament, through an act of Parliament. Now, the Constitution doesn't say directly that the Chief Election Commissioner is superior and other election commissioners are inferior. Not at all. In fact, it says that if there are other election commissioners other than the Chief Election Commissioner, necessarily the Chief Election Commissioner shall act as a chairman. That means he is first among the election commissioner. That's it. It doesn't mean that he is superior and others are inferior. This is very important. However, in the relation to the terms and conditions of the service of the office, it provides a discriminatory treatment, particularly Class 5. There are two provisos under Class 5 of Article 324. The first proviso says that the Chief Election Commissioner shall not be removed. Okay. The Chief Election Commissioner can be removed only in the like grounds, the like manner of a Supreme Court judge. That means what? The Chief Election Commissioner can be removed solely through impeachment. He cannot be removed through other means. He can be removed only by impeachment. So, if there is no impeachment, he cannot be removed. What is the importance of impeachment? All of you know. The grounds prescribed for the Supreme Court judges is also equally applicable. That is proved misbehavior, incapacity, and other grounds specified under Article 124 of the Constitution. The procedure has also been specified for the impeachment of the judges. So the ditto shall be made applicable. The same shall be made applicable to the Chief Election Commissioner of India. So he has been given absolute independence. What about the other election commissioners? They are also performing the same function, but they are not given the equal treatment. This is where the problem arises. The other election commissioners need not to be removed by impeachment. They can be removed by a law made by the Parliament, but they cannot be removed without the recommendation of the Chief Election Commissioner. Okay. What is the problem here? All of you may ask me, what is the problem here? Say, in a majoritarian tyrannical rule, when the government has a brutal majority, And if the Chief Election Commissioner is colluded with the government, then all other election commissioners, their official role is meaningless, because there is no independence. They have to act as per the whims and fancies of the Chief Election Commissioner. Otherwise, the Chief Election Commissioner may threat them. There is a threat that the Chief Election Commissioner may recommend their removal, and so as to please the central government. Say example, last time we had a problem. After the 2014 election, Prime Minister Modi has assumed the office with a brutal majority. Of course, comparing this time, it was a little lesser majority. But after that, during the 2019 parliamentary election, there was an issue whether the PM has violated the model code of conduct or not. The Chief Election Commissioner and one election commissioner has voted in favor of the PM. Other election commissioner has voted against the PM, that the PM has violated the model code of conduct. Remember, now this other election commissioner who has acted independently, his office can be threatened, because if the CEC recommends, he can be removed. So, when they are performing the same function, same treatment shall be given. Otherwise, there is no meaning making the election commission as a multi-member body. This has to be checked, because free and fair independent election commission is a basic structure of the constitution. Free and fair poll is a basic structure of the Constitution of India. Since these powers have been prescribed, or these concepts have attained the status of basic structure of constitution, then how it can be regulated through a law? But such a constitutional challenge has to be made before the court of law. I am sure the court will rule against these sort of provisions, because these are all unconstitutional, because this is violating the spirit of the true democracy of our constitution, because free and fair democracy is a basic structure of constitution. To preserve this basic structure, the entire independency of the election commission ought to be maintained, and not the mere CEC independence alone can safeguard the electoral process. This is my humble submission. Then you have Article 325. It talks about preparation of electoral roll. There is no special electoral roll. All members shall be prepared in one electoral roll, general electoral roll. This roll will be applicable for both parliament as well as legislature. Thereafter, Article 326 talks about adult suffrage. What is the adult suffrage? Any person who has attained the age of 18 years can take part in the elections through his voting powers, voting rights. The age has been lowered from 21 to 18 by the 61st Amendment. Please remember, 61st Amendment can be a question in any of your examinations. Thereafter, Article 327 talks about the power of the Parliament to make laws relating to the elections, particularly delimitation of constituencies, preparation of electoral roll and other aspects. Subject to the Article 327 and subject to the law made by the Parliament, if there is anything left out, only that portion can be regulated by the state in relation to the state legislature election is concerned by the state legislature. So state legislature power is very, very limited, whereas the power under Article 327 of the Parliament is wider than comparing the power of the legislature under Article 328 relating to the law-making power of the elections is concerned. Then we have Article 329. It talks about bar of courts in entertaining certain electoral matters. So these are the few aspects. Please remember it. God bless you all. Jai Hind.